request is filed, the application is being withdrawn. And what is the form for expedited examination? 18A. Yeah, section, the same section. What is the primary importance of priority date under section 11? It determines the patent term. It is the date against which novelty and inventive step are judged. It is the date fees are due. It is the date the patent is granted. Okay. An inventor files a provisional application on January 1, 2024 and has complete specification on December 1, 2024. If a claim in the complete is fully supported by the provisional, the claim is supported by the provisional. What is its priority date? Each claim has a priority date depending on when that was supported or filed. So, January is correct.
Second.
Huh?
Second.
Okay. If a claim for matter disclosed only in the complete specification, not the provisional, what is the priority date? I'll tell you the one. The second one is December 1, 2024. Okay. This is a separate one. If a claim for matter disclosed only in the complete specification, not in the provisional, what is the priority date? 1%.
First. Date of provision.
It is disclosed only in the complete specification. Date of the complete file. An applicant files in the USA on March 1, 2024 and then in India on February 1, 2025. What is the priority date for the claims supported by the US filing?
Second.
The second one is the date the US patent grants. Listen to the question carefully. An applicant files in the USA on March 1, 2024. India, February 1, 2025. Question is, what is the priority date for the claim supported by the US filing? March 1, 2024, date of the US patent grant. February 1, 2025, the day of Indian publication. Can a single patent application have claims with different priority dates? Tell. Loudly tell. Can a single patent application have claims with different priority dates? Claims can be amended, claims can be added, but the description cannot be. So, can a single patent application have claims with different priority dates? Yes, it is possible, especially if applications derive from multiple provisionals or a convention application. Is everybody with me? This is a complicated situation. Have you understood? Huh? Because there will be bigger questions later. Clear? The priority date is determined by the controller based on the fee paid by the applicant, the request of the applicant, complexity of the invention, the content of the priority document and the claims. Why everybody is going boring? The priority date is determined by the controller based on the fee paid by the applicant, request of the applicant, complexity of the invention, content of the priority document and claims. What's the answer? Everybody agrees? When is a patent application typically published under section 11A? Never. After the patent is granted, immediately after filing, after 18 months from the date of the priority filing?
After
18 months. What is the main consequence of an application being published? It becomes part of the public domain and can be used by anyone. Examination process begins. It is granted automatically. Invention becomes publicly known and the applicant gains provisional rights. Published. Examination process begins when you request for examination. The invention becomes publicly known and the applicant gets it, right? Which applications are not published under section 11A? An application, all applications are published. Applications withdrawn before publication period and those with secrecy directions. Applications filed by individuals. Applications for software. So the answers are which are not published under section 11A. 11A means the regular file, 18 months after priority date, it is published. When is it not published? So, second one. That means applications withdrawn before publication period and those with secrecy directions. So you can do that. If you don't want it coming into the public domain, you withdraw it before it is published. That means which incorporates that method to treat is patent. Similarly for human beings, for prophylactic or other kinds of treatment, it's not patentable. Medical treatment. Plants and animals per se are not patentable with the exception of microorganisms where there is human intervention. Okay. This happened because of the polio vaccine, the bacteria that was in the Calcutta case, right? So there is one exception there. Software per se, this is section 3A. It's a big section because we have a lot of algorithms. We're making this artificial intelligence and so many things are happening for technology. Per se, software, algorithms, mathematical abstractions, none of this is patentable subject matter. Which is the intellectual property right that you will use for this? Copyrights, that's correct. Copyrights for algorithms and software. So, however, if you are using an algorithm in a device, is that patentable? That device is patentable. Just the way of thinking is the same. Method of agriculture is not patentable, but that method is incorporated in a particular implement that is patentable. The method of treatment of an animal is not patentable, but if you incorporate that method in a device, then that's patentable. For example, endoscopy, it's a method of diagnosing. Endoscopy per se is not patentable, but if you put it in a pill and make you swallow it, that pill becomes patent. You have probably, many of us have undergone endoscopy, right? So that pill becomes patentable subject matter. Okay? Traditional knowledge, that is also not patentable. Can you tell me why? It is known from agents. You cannot say that it is not. Okay. Now, so this was section 3 and section 4 is total bar on anything to do with atomic energy. Absolutely no. You know, the other sections you can say I will put it in a device, I will put it here, there, but